Hello, today we're going to talk about the constitution of a trust, which is section 7 in your subject guide. I heard that some of you did your exams last week. I really hope that they went well. You may not be continuing with this course, but if not, please pass on my best regards. I did think of you and sitting all of your exams this week. I know it's been a difficult time to sit them with the course having been taught partly remote, which is a bit of a shame. But for those of you still continuing with the course, I'm afraid I don't know how many of you there are. Today we're going to be doing the constitution of a trust. Now, the constitution of a trust is about what is done with the legal interest in creating a trust. Now, remember last time we did formalities, and formalities are very much about how the equitable interest in a trust gets transferred. But in constitution of a trust, we're actually talking about the legal interest and what happens with the legal interest to create that trust. So if we remember that we've got all of our property rights all as one, when we create a trust, we split those property rights into the legal and the equitable interest. Now, when we're talking about formalities, we're talking about the way that we often transfer or prove that this equitable interest has been transferred. But with constitution of a trust, what we're talking about is what happens to this legal interest. The important thing to remember, and this is really, really important, is that if I want to create a trust and I split my legal and my equitable interest and I give away the equitable interest and I keep the legal interest and I myself am a trustee, nothing needs to be done about the constitution of the trust. Constituting the trust means what we do with the legal interest to make someone a trustee. But if we're making ourselves a trustee, remember that as far as the law is concerned, nothing has happened. It's only equity that's concerned with whether or not a right has been transferred. So if I'm keeping this legal interest, nothing needs to be done about constituting it, because as far as the law is concerned, nothing has changed. What we need to worry about is when I have these rights and I split them and I give the equitable interest to one person and the legal interest to another person. And what we're worried about is whether this legal interest has been properly transferred. And importantly, as far as the law is concerned, in some ways the law is ignorant. It doesn't know that there's a trust involved here. And so when we talk about what happens when we constitute a trust, we are also talking about gifts. And gifts are where you give the legal and the equitable interest in something away. It's just the whole property right and it's given to someone else and I don't have it anymore. So you'll see that quite a lot of the case law deals with trusts and gifts. And arguably when exceptions are found to mean that equity sees that an equitable interest has been given away, what happens is where there's meant to be a gift, there is actually a constructive trust, and because the court has construed a trust from the property. So the first part we're talking about the different ways that this legal interest is transferred, and this is true really for, even if you're giving it away. Remember that with a contract, there doesn't need to be this sort of constitution apart from with land, because you're giving it away for consideration. So the law recognises that this consideration has been given and that transfers the interest, and there's not the same set of rules. But if you're just giving something away, or you're doing it you usually have to do it by deed, or you have to do something that shows that you're giving it away, because you don't have that consideration there to show the law that this is what you're doing. So for land, obviously you do have to have a deed, you have to register it with the land registry, but you normally, the land registry requires you to sign the deed before it will recognise something to be registered anyway. So with legal interest in land, you might see, you would probably fill out what's called a TR1. You don't need to know this, but in filling out a TR1 for the person to give it away to sign it, this has to meet all the requirements of a deed, so you need to have a witness to the signature. Chattels are anything, chattels are any object. A chattel could be this mug. And normally what you have to do with chattels is you have to transfer possession, or you have to transfer something that symbolises possession. So if I was going to give away my car, what I might actually give away is the keys to my car, because I can't move my car until someone drives it off. But if it's, say, a t-shirt, then I probably have to give the t-shirt over to the person, or for whatever reason, I might give them permission to go into my house and collect it. But they have to take possession of it for ownership of the chattels to be moved. That can get a little more complicated. We're not too worried about that in trust. Shosen action is the other one, and this is quite common. A shosen action is something where the actual possession isn't transferred over, a right is transferred over. And even money in a bank account can be a shosen action. If you've got money in a bank account, you don't actually own that money. What you own is a right to sue the bank for the amount of money that you've put into it, plus some interest normally. So a shosen action can be really any right that you own, any right that you have on your estate, and it depends on what that particular right is for it to be transferred over. One of the most important ones, the most relevant ones for the case law, is a share. So if you've got a share in a company, you have a shosen action for certain rights in the company, and the transfer of that has made up a lot of the case law, partially because usually in company law and normally in limited companies, to transfer shares over, the company secretary needs to register the right has changed to a different person, normally in the company ledger. And so there's a time lag between the person who originally owned the shares giving them away and the person who's going to get the shares actually taking sort of possession of them or being recognised as the owner by the company. So there's that time lag, and that's what's caused some of the ambiguity in the law. And then you can also, as we discussed last time in Van der Waal and IRC and Gray, you can actually transfer as well an equitable interest under, if you are the beneficiary of a trust, you can do things with that equitable interest. But as we discussed last week, that needs to be done in writing under section 53(1)(c) of the LPA 1925. Normally, it does make a note that normally constitution isn't really a problem for testamentary trusts either. Testamentary trusts being ones that are created in a will. The reason being is normally all of these rights sort of come back to the executor, and it's the executor's job to start constituting them out. So they normally do that professionally. And rights is sort of being parcelled out, and legal rights are already in transit, so it's much, much harder to make a mistake, basically. And it's on the executor to make sure that that's done properly, which is why testamentary trust is rarer to have problems with constitution.